SJC-13615, Commonwealth versus Daniel Spaulding.
Okay, Attorney Allen, whenever you're ready. Yeah.
I believe good afternoon, Your Honors. Ashley Allen for, on behalf of the defendant appellant, Mr. Daniel Spaulding. May it please the court. This case involves General Law Chapter 268A, Section 23, which is commonly known as the Conflict of Interest Statute, and the criminal component of that, which is Section 26. And so, unless this court has another preference, I actually want to start with my last issue, which is whether there was sufficient evidence of the actual amount of the unwarranted privilege. So whether or not it was over, the fair market value was over $1,000 or more. I think that's a mathematical problem, and it might take a little time to get
Do
through.
you have any legal authority for the proposition that the fair market value of cash is not its face value?
Well, so it's not a case that says so, but here I think it's limited by the indictment, how they charged the indictment, that it was the use of the money, which was the unwarranted privilege, how they argued the case. They conceded right from the beginning in opening statements that there was no intent to steal, that this was a borrowing. So similar to a loan, it's the use of the money that is the value. And they also conceded as much during the argument.
Right, so ultimately the money was used, as I understand it, to help make mortgage payments, right?
That's the inference, yes.
Okay, so assume that's true. Normally mortgage payments constitute both a repayment of principal and of interest. Why isn't the full amount of the mortgage payment the fair market value of the let's call it loan he gave to himself?
Right, because he's paying that money back. So it's the use of that amount of money for that period of time to cover the mortgage payment.
Well, let me put it to you another way. By doing that, he saved his home perhaps from foreclosure. Why wouldn't we use the home's value?
Well, so if you also look at any of the ethics opinions, if let's take another example where somebody uses their position they use their office and their phone and their assistant to do, and this is one of the examples that the Ethics Commission gives, is to write their book.
But that's not cash.
Right, but they're not valuing the office, the phone system, and the assistant's time there. So what is the use of that during that period? So it's not the whole sum total of the actual property, but the use of it that is what needs to be the fair market value over $1,000.
I'm going to give you a hypothetical, if I may. We have a classic bribe case, let's just take it that way, where you ask a government official to do something in exchange for a bribe, cash, $1,000. And the public official doesn't actually do anything with the cash, just keeps it, makes no money on it, just keeps it. Why is the fair market value of that cash not the face value of the cash?
Because he doesn't use it and then give it back. So he's still keeping it. Where the Commonwealth is one that chose to charge it this way and chose to present their theory as this is not an intent to steal, this is a borrowing.
So that was the choice. That's the way the case was tried. It's
Right.
not necessarily true that the fair market value of $17,000 is not $17,000. It's just that the theory of the prosecution was that it was the time value of the use of that money, which was what was the unwarranted privilege.
Well, that's what they limited themselves by arguing that way. They charged it that way.
But
in the
nothing in
indictment.
the statute requires that kind of construction.
Well, I think the only thing that is required by the statute is that the fair market value be established. It's not the total sum, it's how much does that cost? So,
This is a sufficiency claim, correct?
yes. So we do raise also as a void for vagueness as applied to this set of facts, but not the fair market value portion. So I don't think that it's overly vague. This is that they didn't prove this beyond a reasonable doubt that the fair market value of the use of this money and whatever that sum is. So the Commonwealth in their, I apologize, the Attorney General's office, in their brief,
Still the Commonwealth,
they,
I think.
they pick three different theories, basically. So first they say that it's the sum total. It's not our position that it's a sum total, and it's the use of that money of the sum total. Plus, it's limited to 12-month period. So this, in their chart, they give you, I believe it's a 26-month period, and say, well, here, even if
Should we consider this a no-interest loan? This is a no-interest loan, correct?
if you want to consider it that, then there's
What?
no fair market value to a no-interest loan.
Well, no, it's the
yeah.
present value of all the money and the use of the money over that period of time, right? So it's the best loan available.
It is.
I mean, he's using this evidence as a private piggy bank.
So I think here, though, it would require too much piling of inference upon inference in order to say that this is what the interest would be on this type of loan during this time period. We also don't know when this money was taken. They didn't establish the 12-month period.
Counsel, I'm sorry to interrupt you, but can you tell me, how was the jury charged to divine the amount in controversy?
So this was actually a jury waive trial. So there
Oh,
was.
I'm sorry.
There was.
But he still had to, I'm
Yeah,
assuming.
so there was an argument that he moved for required finding not guilty. The judge determined that he was going to decide the fair market value based on the use of the money. And what he used as the benchmark was there was I believe 3 loans, maybe 4 loans, that the Commonwealth had submitted to show motive. So to show that here's this person who's in financial hardship. He needs this money to pay his mortgage. He had to take these loans. And so there's various loans that he takes over a course of time. They ranged in interest from 9.5, around 9.5 to 11.75 at various times for different amounts of money over the course of time. So the judge used that amount to say, well, here's the evidence of how much it would be. It's our position that that's far too, there's too much conjecture to say that that's how much it would cost here. There needed to be an expert, and it's commonly done in cases where they do property assessments and the fair market value of properties that the parties was.
But if the evidence was that he, or in combination with his wife, had taken these personal loans, and there was testimony as to what the interest rate was on, and that was in the record, so I got it, so I'm assuming that it was before the judge. What is wrong with the trial judge using what he was getting at the time for interest rates on what he was borrowing in using the 1 year, the $16,000 and ascribing that to that? What's wrong with that?
So 2 things I don't think that it transfers automatically to these. We don't know when the money was taken. We don't know when it was returned. We don't know how much money during that 12-month period that they allege was used, the use of the money, not the sum total. Second is that would be taking the chart that was submitted with the brief. And even if we take that, even if we say, okay, let's give them the highest interest rate that's in the record, which is 11.75, they get to, and maybe I'm wrong in my interpretation, I also believe that this is why there needed to be some sort of financial expert, because these are not common knowledge type topics that we can easily understand what the interest rate would be and how much to calculate. But so the Commonwealth says that at the end of 26 months, it would be $1,269 would be the total sum, or the total market value. We need a 12-month period. So if we were to take that as true, my calculations of the 12-month period prior to May 17th, 2017 would be, I believe it was $650. So we're still underneath that $1,000.
Why do you say a 12-month period is the only aperture?
Because the statute, section 26 limits it to a 12-month period. So it says it needs to be $1,000 within a 12-month period, the use. So what they've said is $1,269.10 is, their analysis is based on 26 months. So that's, even if we were to take that calculation as true and use the 11.75 and this chart that they've submitted, it still doesn't get you to the $1,000. And we're not saying that he would still fall in between a civil violation, but the problem here is that we're taking a civil violation and turning it into a criminal offense where there's higher penalties, and that's the problem with the.
If you take the evidence in the light most favorable to the Commonwealth, why was is the trier of fact required to find that this was a loan? There's certainly sufficient evidence to think to conclude it only became a loan once he realized he was being caught.
Well, again, it goes back to how the Commonwealth charged the case and how the theory that they presented, and he did use that as this was like a loan.
So they could have charged him with larceny, and they didn't.
They could have charged him with, I question why they didn't charge him with larceny, by embezzlement, embezzlement by a city employee. And the question is, would they be able to prove it? Because there was no intent to permanently deprive. Case law says that you don't need to show that. So,
I don't know about that, but.
Right, so that's where, was there misconduct? Yes, we're not denying that there's misconduct. There was probably a civil violation. Could they have charged him with another offense? Probably, but this does not fall under the criminal conflict of interest statute.
I mean, that goes to your vagueness challenge about whether or not someone would be alerted that this is a crime, and this is certainly a misuse of office, benefits that certainly aren't available to anybody else, to use the evidence room as your piggy bank.
Right, and so to start with that argument, I will go into that if there's no other questions on.
There is just one, because it relates to Justice Wolahojan's earlier point. Is where the trial judge went wrong here by articulating what his math was based on?
I don't know if he ever.
Because if he says nothing, right, and just finds him, guilty of this, but he very well could have said, I think that the face value of the money is the metric for the loss, versus I'm going to use the interest rates that he was getting on these personal loans, and he's saying, this is my math. And then if the math over the 12-month period is less than $1,000, then the Commonwealth loses.
I think we're in a position where, because we raised a sufficiency of the evidence, and it wasn't, we're not arguing an abuse of discretion. So however he decided it, we would still raise it same as an abuse of a sufficiency of the evidence challenge.
So that would be evaluated at the close of the evidence.
I'm sorry, what was that?
The sufficiency would be evaluated at the close of the evidence.
Correct.
It's not really dependent upon the judge's explanation of his reasoning, correct?
Right. Yeah, so we would have raised it the same way, and it was raised this way. He just agreed with us that this was the use of the money versus the total sum, in this case specifically, because of the way that it was charged.
Maybe you could address the vagueness argument.
I will, Your Honor. So to start off, I just want to say that this was enacted in 1962. It wasn't until 40 years later, about to 2009, that they added the criminal component, and that was to address the issues with corruption at the time, then Governor Patrick. When they first enacted this, it was very broad, very sweeping. It was intentionally vague by design so that it would cover all sorts of misconduct, appearance of conflict, and actual conflict of interest, bribery, all sorts of issues. So that was really the purpose of the statute. It wasn't until later that they added the criminal component without ever changing the civil portion. When they added the criminal component, it added fraudulent intent, and it added the fair market value in the 12-month period part. So we're challenging the unwarranted privilege because as it was written under the first section 23, it was meant to be all-encompassing. And in a civil statute, that's fine. The court tolerates that because the penalties are less, and you have the ethics commission who's the one who's prosecuting these things. You prosecute.
This is an as-applied challenge, correct?
Right. So,
And don't we simply define the crimes by the conduct that's in front of us to say whether it's sufficient and that provides parameters?
well, you still consider the purpose of the statute and the ordinary meaning and
But
as applied
isn't
to
the
this.
isn't the purpose of the statute to say that Commonwealth employees shouldn't use their official business, their positions to get benefits that other people don't get?
Well, yes, and that was what
And that's not a
Comtois said. But in that, again, it was a civil case. They weren't challenging it as void for vagueness. And so we're relying on the Ethics Commission to define what unwarranted privilege is there. So once we've put it into
Does Joe Q. Citizen get a right to go to the evidence room and take out money?
He doesn't, but the question is this a criminal or a civil offense? And so where we're now under the criminal
Well, the question
umbrella,
on
it
void
needs to
for vagueness as applied would be, would a person of average intelligence understand that going into the evidence room to borrow money violated the statute, right? That this was a privilege that Joe Citizen did not have.
I would agree with that. I mean, that's an overarching standard, but we looked, it needs to be strictly construed against, because this is a criminal case, that it needs to be strictly construed. And so if there's any ambiguity in that, then he needs to be given, the defendant needs to be given the benefit of that.
But what's
And
the ambiguity in that? What would a person of average intelligence not understand about the fact that I'm a police officer and I have access, one of 3 people that has access to this evidence room, and I'm going to borrow money to pay my mortgage?
So that's where it goes back to, yes, this is unethical, but is this an unwarranted privilege? What's the definition of a privilege? And here, they've defined privilege as some sort of legal authority. He didn't have legal authority to do this. He was obviously going against his duties as an officer to go into the evidence room. The statute was meant, I mean, there's so many things.
You're getting caught up
examples.
because it doesn't make sense.
But so there's so many examples of, and the Ethics Commission had submitted a letter with hundreds of pages of different unwarranted privileges. And so they were someone getting a vacation, someone using their position as a board member to get a police officer to go fix some sort of utility for his daughter, like things that's so all-encompassing that when we put it in the criminal context, that now we need to look at is this too broad as applied to the criminal context opposed to civil? So I guess it's difficult to explain because of how broad this statute has been designed to far reach all of the conduct. And so, it would be our position that the criminal component does not cure that ambiguity.
Okay, thank you very much. Attorney Johnston.
May it please the court. Assistant Attorney General Tara Johnston on behalf of the Commonwealth. At the beginning, I just want to clarify something for the court. On the chart, I know we discussed how, my sister discussed how it's the interest rate if you apply it the way the judge did in terms of the interest rate, that you get to $1,269 after a 26-month period, and that's not actually accurate. The chart is done on a rolling basis, so you get the rolling interest of $1,269 after a 12-month period within that 12-month period from June of 2016 to May of 2017. So I just want to clarify that at the start, that the judge was correct in finding, if assuming we apply his interpretation, which again, the Commonwealth, as it stated at trial, does not agree with that view of how it should be interpreted, the fair market value. But if you apply that view, you still reach well over the $1,000 within that 12-month period. Looking at how, just quickly, the sufficiency argument, because I know my sister started with that, and just addressing that, as I just said, the Commonwealth satisfied it with respect to the if you apply it how the judge applied it in terms of looking at it with interest. And there is no expert testimony needed with respect to the math here because we had Mr. Spaulding's financials, and that included the interest rates he was getting on loans in the period
Which
of time.
interest rate is used in your charts?
The 11.75 interest rate, Your Honor, and that is what he received on 3 of the 4 private loans he received during this range of period of time. However, it is, as the Commonwealth argued at trial, the Commonwealth's position is Mr. Spaulding had access and was using the full 17,000, or had access to and had available to use to him the full $17,611 that he took from the evidence room. And he was using it, as this court has pointed out, as his own personal piggy bank. He was using it throughout throughout many years, but throughout that time, he had that to help make mortgage payments. He had that to, I believe he made the mortgage payments previous to that 12-month period, but he had it to pay personal expenses, and this was money he needed. All of the financials were before the judge, and that actually was in Exhibit 71, which was submitted to this court. So there was no reason for expert testimony in this case because the judge had all of the information he needed to make that determination. However, as the Commonwealth argued at trial, again, Mr. Spaulding had this full amount. He had this full amount in his possession, and he did not return it until May 22nd, 2017, after he was instructed to return it by the chief of police. So in that, he was using this money, the entirety of it, and he had it, and he didn't have a loan for this money. And also, I want to highlight the fact that this just isn't cash. This is evidence room cash. And that was actually brought out at trial by the prosecutor, right? This isn't, when we normally think of cash, we normally think of something that maybe is more fungible, right? It's replaceable. And agreed, Mr. Spaulding did eventually return the evidence bags.
So do you think that the fair market value of evidence cash, as you called it, is different from the fair market value of other cash?
I would say, Your Honor, I think that in both circumstances, it should be viewed as the prosecutor argued it, but I think there's an additional reason here that because it's evidence room cash, there's no way to ever really replace that. And I think one of the things the trial judge brought out at trial is, well, I would view it as a face value if it was a consumable, like his tickets to a show or tickets to a game, because once the event happens, whether or not the person who takes advantage of that privilege goes to the show, throws the tickets in the garbage, gets sick and doesn't get to attend, once the show is over, they have the ability to attend that show, to attend that game. And then once the show is over, it's done, you've secured the unwarranted privilege of that face value, that full value of the tickets to the show. And you can't then press rewind and put different tickets in its place. And I think that would be the same as evidence room cash. And the Commonwealth actually presented evidence, and the dockets, I believe, are in the record appendix of these cases. 2 of the cases were ongoing when Mr. Spaulding took this money from them. He was breaking chain of custody, he was compromising cases, and these are not, he put back bills, but as we know, they weren't the same bills, right? There's 135 replacement bills in total in those 3 bags, with a sum of over $5,000. So there's at least 135 replacement bills at a minimum. Within the 12-month period before he returned them, 70 replacement bills, totaling $2,880. He was using this money, and then when he did return evidence bags, and yes, they had money in them, but it wasn't the same money. And so I do think that is an important distinction, and it was highlighted by the prosecutor at trial. But even with respect to cash, I think that I don't think in looking at the statute, any reasonable person would look at the statute and say, over $1,000 in fair market value, oh, well then I can take a large sum of cash and use it how I want it, but as long as the interest accrued over a 12-month period wouldn't exceed $1,000, then I'm good under the statute. I'm not I'm not criminally liable because I just get past that. And it would lead-
Did the Commonwealth argue below that the fair market value was the face value of the cash?
Yes, the Commonwealth's position throughout was that it's the face value of the cash.
And how do you reconcile that with the theory of the case, which was that it was a loan?
I don't think so. I don't think the theory of the Commonwealth's case was that was a loan per se. That was what the judge said. I think the Commonwealth's theory of the case was that he returned it, which he did. He returned the evidence bags and with replacement bills. And I think in the indictment it actually says that he returned the bags and he replaced the money. He replaced it. That is different than returning something. He replaced it with something else. So, but I don't think that the Commonwealth, from the Commonwealth's perspective, this was ever a loan. And
So was the fair market value the 5,000, the 17,000?
I think it was the 17,000 because they had the ability to look at, to use all of it. And if we look at some of the State Ethics Commission's cases.
And that's how the case was argued?
It was argued that he had the full $17,611, yes. And I want to also touch upon the vagueness issue because I think as a common sense person, a person using their common sense, reading the statute, would not think, especially a public official, would not think that taking money from an evidence room, that there was no, that there was somehow, it was not, they were not criminally
Especially a police officer.
Especially a police officer, Your Honor, yes. There was clear fraudulent intent here. There was deceit. There was misrepresentation throughout. When Mr. Spaulding entered that evidence room, he knew that he was only supposed to be entering it to protect the evidence or look at the evidence in his capacity as a police officer. And how is this highlighted? This is highlighted from the fact that there was a key fob, and there was only 3 people had access to this evidence room. He knew what he was doing, and he was acting with deception when he went into that evidence room and he took out that evidence and he used it for his own personal use. And that continues throughout, that deception and that misrepresentation. It continues through all of his acts of what he did. It continues when he's using that money for his personal expenses throughout that period of time. It continues from the time that he's informed by the police chief in October of 2016 that there's going to be an audit, and even at that time, he does not divulge that he has this money. It continues through the time when he's actually asked about this money by investigators, and he lies and says that he doesn't have it and he doesn't know where it is. It continues through the time that waits 3 days to contact the police chief and then inform the police chief and finally confess to having it. And then it still continues because even at that time he isn't forthcoming. And even at that point, he lies and says the reason he took it was because he believed the bags had been compromised, when in fact we know that's not true, which was shown by the subsequent investigation, the ongoing investigation. So this all is just completely, there is no public official who would think that this was not acting with fraudulent intent or that he was not obtaining an unwarranted privilege, which that term also commonly understood, an unjustified benefit by taking this amount of money throughout this period of time, having it available to use as his own personal piggy bank. If there's any other further questions from the court, otherwise, I'll rest my brief. Thank you.